Hi, and welcome to the Why Should I Care Civil Procedure podcast. I'm really excited for our guest, Professor Adam Steinman of the University of Alabama School of Law. And Adam is going to talk to us about personal jurisdiction. So, Professor Steinman, why should I care about personal jurisdiction?
Well, it's a great question. And obviously, thanks so much for having me on your podcast. So, when we're talking about personal jurisdiction, we're talking about whether a particular court has jurisdiction over a particular defendant in a particular lawsuit. And we should care about personal jurisdiction for a few reasons. So, one is it's an area of the law that can really help or really hurt your case when you get out and start practicing law, right? Getting into a court that's advantageous for your client and your litigation strategy can really help you get a better result. And getting stuck in a court that's not advantageous for your client or your litigation strategy can really lead to a worse result. So understanding how to win arguments about personal jurisdiction is an important way to put your client, put your case in the best possible position. So, a second reason I think we should be caring about personal jurisdiction is it can have a big effect on whether the laws that govern so many aspects of our society are actually going to be enforced, and that those who violate those laws are actually going to be held accountable. If you think about a person, they live in a state, they suffer some sort of injury in their home state, right? Maybe it's a product they use, maybe it's a medicine they're taking or something like that. Right? The events, the after effects of that injury, they're all occurring in that home state. But the defendant who's responsible, right? Maybe the manufacturer, the pharma company, they're located outside of the state. Maybe they're even located outside of the country. The plaintiff can only sue in their home state if they have personal jurisdiction over that defendant. And what that often means is if we force the plaintiff to go to a distant state or even go to a foreign country because there's no personal jurisdiction at home, then the practical consequence may be you're never going to get the lawsuit decided. And personal jurisdiction then can really mean the difference between convenient, effective enforcement of tort law, of safety standards, and the like, and having no enforcement and no accountability at all. So then a third reason I think is it's just been sort of a hot topic for the last few years. When I first learned personal jurisdiction back in the previous millennium, the Supreme Court had just finished a decade or so of pretty heavy activity on personal jurisdiction. So there were a lot of big decisions from the late 1970s throughout the 1980s. And then after 1990, the court just kind of gave up on the topic for about 20 years. And then starting really just this decade, about 9 years ago, the court got back into the game. And so it's issued a bunch of new decisions on personal jurisdiction. As you know, it just heard oral argument back in October in another big case, the Ford case, that's going to affect personal jurisdiction doctrine. So it's an especially kind of interesting topic just because it's fun to be engaged in an area of the law at a time when the doctrine itself is evolving.
So, some people, Professor Steinman, and I don't know if you're one of these people, they think personal jurisdiction doctrine is too confusing. It's all over the place. So, our listeners know, or they're about to know because I'm going to tell them that the general standard, right, is that the defendant have such minimum contacts that if he be not present in the forum, right, that it's that exercising jurisdiction over it or her or him comports with traditional notions of fair play and substantive justice, right? That's the standard. And it's a pretty malleable standard. A lot of stuff fits under that standard. So in class, we'll talk about purposeful availment, or we'll talk about stream of commerce, all these things, right? And I've read a lot of articles where professors say, look, it's so confusing, it's all over the place. What's your position about that? So how do we think about it in terms of some kind of coherence, especially for students who are thinking, well, I'm going to have to apply this stuff on an exam. I'm going to get an exam question on this. I'm going to have to apply it. But is it really all over the place? What do you think?
Well, I do think that one of the big struggles with this area is that there is a lot of uncertainty and there is a lot of indeterminacy. And, like you're saying, we have this sort of pretty broad overarching framework, but there's really a lot of gray area in terms of how that gets applied. And, it's not helped by the fact that you read these decisions, right? You read Asahi Metals and you can't even get a majority of the court to agree on a particular approach to an issue. You read, Jay McIntyre versus Nick Castro, and you can't get a majority on one of these issues. And so, I think that's correct in terms of describing where things stand. Now, we could kind of go into how should things be? Like, is there a better way that would give more clarity? But that's not going to be much help to your students who are going to have to take a test applying the admittedly kind of uncertain framework that the court has given us. So, I think the best advice to give a perhaps unsettled first-year law student who may genuinely and understandably want to know the answer, right, to a legal question, right? Is there jurisdiction in this particular situation or isn't there jurisdiction? Sometimes the best you can tell them is just embrace the uncertainty, right? This is where lawyers can really make a difference, right? By understanding how best to marshal evidence and arguments the best way you can. And, to be comfortable with the idea that because I don't know the answer doesn't mean I don't understand the material. It just means I need to understand the full range of possible arguments that I might make within this admittedly ambiguous framework the court's been giving us.
Yeah, so what I sometimes tell students, and so that to put what you've just said in a more concrete way, sometimes tell students, look, you're not looking for like the platonic right answer to the question. What you're looking for is to be able to make these arguments. And one way to do that is to put yourself in the position of a lawyer with a client, right? So if you think, okay, I represent Ford Motor Company, I do not want to be in Minnesota. I don't want to be sued in Minnesota. What is my best argument for the position that I shouldn't be able to be sued here? And I'm the plaintiff. I want to be able to sue in my home state of Minnesota. I'm just using the Ford case as an example, right? What is my best argument that I should rather be able to exercise jurisdiction over this company? And that makes things a lot easier because you're not trying to figure out the answer to personal jurisdiction problem, leave that to the professors or the justices. What you're trying to do is just marshal the best arguments on both sides. And then you can reach a conclusion, whichever argument you think is the better of the two. But that isn't really ultimately like the point of answering the exam question. The point is to show, yes, I can marshal these arguments. I can use the facts to support one side. I can use the facts to support the other side. But I just want to follow up with a question about the ought. So what ought be the rule, which is, what do you think, if you're willing to answer this, do you have a sense of the politics? And I think you've written a little bit about it, the politics of personal jurisdiction. That is, you mentioned when you were introducing it that one reason we should care about it is that if personal jurisdiction doctrine is very restrictive, and it's because personal jurisdiction is a doctrine that protects defendants from being sued in a faraway forum, right? So if it's very protective of defendants, it means that plaintiffs who are injured in a particular location aren't going to be able to sue in that location. And a lot of these cases have been tort cases recently, right? So you mentioned the Castro is a tort case. The Ford cases that are coming up are tort cases. So I wonder, could you talk a little more about the politics of it? Because one of the things I've noticed that might interest students is that you don't always see these cases line up along liberal and conservative lines at the Supreme Court level, right? We've had a lot of 9-1 decisions or 8-2 decisions, right? No, 8-1 decisions. I can do math. 7-2 decisions, right?
You're already packing the court, right?
I know. I did not mean to pack the court, everybody. All right. So what do you think about that? What do you have, do you have any reactions to the politics of this question?
Yeah, so it's a great question, and I think issues of civil procedure generally are really intriguing on these lines because there's so many different ways they potentially cut in terms of the typical ideologies that you think about in terms of Republican justices and democratically appointed justices. So certainly one general trend I think, as you alluded to, is there is one side of the court might be more inclined to be concerned about the interests of corporations that are likely to be defendants in this sort of litigation. And so, if you look at a case like Nicastro, for example, it was the conservative justices who were proposing the most restrictive approach to the plaintiff who wanted to sue a corporation based on injuries that plaintiff suffered in their home state. And it was the more liberal justices who were proposing, three of the dissenters would have simply upheld jurisdiction in that case. So I think that's certainly one trend that I do think we still see in the cases. One of the interesting components of some of the 8-1 decisions and even 9-0 decisions that you're mentioning is that they all have to do with general jurisdiction, right? So a case like Goodyear, a case like Daimler, right? These are all cases where, and actually, the late Justice Ginsburg was leading the charge in many of those cases in proposing a more restrictive approach to general jurisdiction. But of course, general jurisdiction theoretically permits a lawsuit regardless of whether the substance of the lawsuit has anything at all to do with the forum state. So maybe the strongest example of this would be the Daimler case, where you had a lawsuit filed in California based on events that had happened in the 70s and 80s in Argentina against a German company, Daimler AG. So there's no connection to California, and Ginsburg was skeptical of the idea that Daimler should be subject to jurisdiction in California for any lawsuit. Obviously, we see in some of Justice Ginsburg's other opinions, like her dissent in McIntyre, a much greater sympathy to jurisdiction in cases where it's a specific jurisdiction case, that is, where the lawsuit is about something that happened in the forum. And I think you can plausibly say that is a sensible approach to this. That is to say, maybe if we understand specific jurisdiction correctly, and we make specific jurisdiction more readily available in those kinds of cases where plaintiffs are going to need to be able to sue in their home state in order to get meaningful access to civil judicial remedies, then maybe we can sort of confine general jurisdiction to a much smaller category of cases. The problem now is we have a world where it's very clear that general jurisdiction is quite significantly constrained, and specific jurisdiction is at best a muddle, and there's certainly a lot to point to if you are the kind of defendant who's trying to resist being held accountable in the forum where the plaintiff suffered their injury.
So I want to shift over to one other issue that I really wanted us to address. And it falls into that same category of things students struggle with that I'm hoping you can give them some help with. I've noticed that students really struggle with differentiating between subject matter jurisdiction and personal jurisdiction. And I was wondering if you could talk a little bit about the difference between those two doctrines to help students not mix them up on an exam.
Yeah, so it's a really important issue, and it's complicated a bit by the fact that most first-year civil procedure courses do pay a lot of attention to what's going on in federal court, and federal court is really where you are worried about subject matter jurisdiction limits like the federal question statute or the diversity jurisdiction statute. And those, of course, are the bases for getting into any kind of federal court. So the way I often explain it is subject matter jurisdiction you can think of as sort of a vertical constraint on forum authority, right? It's whether you get to be in some federal court as opposed to some state court. And then personal jurisdiction is kind of a horizontal allocation of forum authority. It's going to apply to tell you where on the map can you be, right? Can I be in Oregon, or can I be in Alabama, or can I be in Connecticut, right? So subject matter jurisdiction simply answers the question whether you can be in any federal court. And then personal jurisdiction is going to help answer the question, which particular federal court can I be in? Which particular federal district can I be in? And of course, if you're in state court, which particular state's court can I be in? And this maybe dovetails with another issue that I've often found students struggling with, which is how do we think about personal jurisdiction in federal court? So once we've kind of aced the distinction between subject matter jurisdiction and personal jurisdiction that you were just laying out, how do we actually do the analysis in a federal court? And it is sort of a tricky issue because, you read these cases and they're talking a lot about sovereignty. And so when we think about state court jurisdiction, one reason we insist on minimum contacts with the forum state is to justify that state's assertion of its sovereignty through its judicial system, right? But federal court, the sovereignty is the judicial authority of the entire United States. But even in federal court, the Supreme Court is still examining the defendant's contact with the state where the court is located. And the reason, of course, is we have Federal Rule 4K1A, which I try to, explain as kind of a self-imposed limit on personal jurisdiction in federal court, right? So there are some fairly narrow exceptions, but usually Rule 4K1A means that a federal court will still only have personal jurisdiction if the state court where it's located will have personal jurisdiction. So in that way, you really can think of personal jurisdiction as kind of creating this horizontal forum allocation system that applies largely the same whether or not you're in state court or in federal court.
And why do you think we have the rule? Why do we think we have 4K? That is, what do you think is the reason to, because one of the things we talk about in my class is how, when we're looking at a federal court's personal jurisdiction, it would be, I think, under the Fifth Amendment's due process, right? Whereas the state's limits are the 14th Amendment due process clause, because that's the one that governs the states, right? So we could have a rule that said, hey, if you're suing in federal court, you get to forum shop, you can sue just absolutely anywhere you want, and we're going to limit you through venue, right? That's a different, within the federal system. And the idea would be, well, the federal, as you suggest, the United States whole is the sovereign, right? And so that there is no limitation as long as you're within US borders. But we don't do that, right? We actually incorporate the state sovereignty idea into the federal inquiry. And I'm wondering why you think that is. Like, what do you think the policy reason is? Because I find a policy reason helps motivate my thinking about what I'm doing when I'm actually applying some doctrine.
Yeah, so there's kind of a lengthy kind of historical reason about how Rule 4 kind of evolved since 1938 into its current form that largely took shape in 1993. This was sort of an effort to make sense of a lot of uncertainty about what exactly that old language meant. I think what you're saying makes a lot of sense. That is, you could handle the kind of horizontal forum allocation question in federal court entirely through venue. And you're absolutely right that the Fifth Amendment due process analysis that we'd ordinarily might apply to the federal sovereign authority would be one that doesn't care at all about state lines. I think the way to think about it, if you're kind of trying to find a hook to just understand why it is this way, is that what they decided to do was say, we're going to leave it up to Congress to unlock that broader Fifth Amendment national contacts test. So if you keep digging down in Rule 4K, you'll get to 4K1C, which says, putting aside any limits that might apply in state court, a federal court can assert personal jurisdiction if a statute explicitly authorizes personal jurisdiction. So if Congress unlocks it, as it has with some statutes, like the RICO statute, for example, then you do apply that Fifth Amendment analysis. And you do potentially open the door to to many more districts being permissible, subject, as you said, to the potential limits that are imposed by the venue statute.
That's a great way of thinking about it. So we're almost at the end of our time, and I wanted to ask, are there any other tips or tricks or final thoughts that you would want to tell students, or that you tell students in your class about personal jurisdiction, either that will help them on the exam, or just why should they care about this pretty confusing, to be honest, and uncertain doctrine?
Yeah, so it is a bit of a hazing ritual, perhaps, for the first year student as they try to process all of these cases. I think in a lot of ways it's a good experience to have. We teach civil procedure in the first semester, but for example, we don't teach con law until the second semester, first year. And I think in a lot of ways, personal jurisdiction is a great way to kind of sink your teeth into some of these issues. So if your first year curriculum is something like, torts and crim law and civil procedure is probably where you're really going to be reading Supreme Court opinions and kind of getting familiar with the justices and their philosophies and different ways of not only interpreting statutes but interpreting the Constitution. Right? These norms, for better or worse, have been crystallized as constitutional law as a matter of due process. And so I think that's another kind of interesting feature of personal jurisdiction. And there's some opinions that really are kind of civil procedure proxy wars for much deeper questions about constitutional methodology, constitutional interpretation. The one that I like a lot is the Burnham versus Superior Court case, where you have another great example of opinions that don't generate a majority, but you've got this plurality opinion written by Justice Scalia that talks all about pedigree and history and originalism. And then you've got this other four-justice coalition that Justice Brennan writes for, that's much more in keeping with kind of a living constitution and adapting constitutional notions to fit with contemporary norms. And so, that's a long-standing debate of constitutional theory, and you see it right there in personal jurisdiction.
Yeah, so if you're a student and you're itching to get to con law, don't worry, Civ Pro's got something for you, right? Yeah, no, I love it. So thank you so much for coming on the podcast. I really appreciate it. Maybe we'll have you back when the Ford opinion comes down for an update on, if they break the whole thing wide open. But until then, this was really great. Thanks so much for coming on.
Sounds good. Thanks. Yeah, we'll do an emergency podcast for Ford.
Okay, great. Bye-bye.
All right, see you.